We are very fortunate to have with us today a highly experienced employment law attorney. Janette Levey Frisch has over 20 years of legal experience, more than 10 of which she spent in employment and HR law, acting as the employer's legal wellness professional. What are the do's and don'ts of, well, let's get an ad out there?
Well, there's a sweet spot that employers have to sort of hit, because on the one hand, whether it's advertising or the interview, when you have the candidate in and you want to ask them questions, you want to do your due diligence on one hand, make sure you're making a good hire. Then on the other side, you want to avoid a discrimination claim. So how do you do that? There are certain questions that you ask on an interview, you're asking for discrimination claim. So there are certain questions that I would say either don't ask at all or wait till after a conditional offer of employment. So with respect to anything that could reveal that somebody has characteristics like their religion or a disability or their gender, anything that focuses on that, should not be asking about it. Keep it related to the job. Keep it related to the qualifications for the job.
But what about inadvertent sexism?
Ooh. I have a story of my own with that. Actually, when I was looking for a general counsel position, I went in on an interview, and the gentleman who's interviewing me was trying to be conversational, and he's talking to me, and I said, "Oh, you have any children?" And I looked right across at him, and I said, I would be remiss, since I'm interviewing for a general counsel position, if I didn't tell you that you really shouldn't ask that on an interview. And he was flabbergasted. He thought he was being nice and making conversation. That's not relevant to the job. It's not something to ask, especially on a first interview. Well, if you think about any situation where maybe you have hired somebody to do work for you, maybe it wasn't an employee, and you did business on a handshake, and then what happened later when you had some questions, you have some misunderstandings, you have nothing you can refer to. So your agreement is something you can look back and you can refer to right away and say, okay, well, what does our agreement say? Because that's the first place you would look at. And if you don't have that, so you don't have that safety net. And if you have a well-written employment agreement, it can smooth over a lot of those wrinkles or maybe even avoid them in the first place. Employment agreement doesn't go through all the minutia of employment. Those are just certain key points that you include for your protection if you feel there are things that need to be protected. The Employee Handbook, yes, that's an appropriate place for social media, cell phone usage, and related topics like that. And the other provision that is important to have in there is this is not a contract. Right? So this is, the Employee Handbook is to give you information about what you might reasonably expect working here, but management reserves the right in its sole discretion to change the provisions at any time. So hopefully that's the difference between these documents.
Do your employees sign to accept that those behaviors or expectations on them? Is this a signed document?
It's a good idea to have an acknowledgement of receipt that you get the employee to sign. And even if they don't actually read it, and by the way, not reading it is not a defense. That does not mean that they are not responsible for knowing what's in there. You can't make employees read a handbook, but you can and should get a signed acknowledgement of receipt. But also in general, I would say that it sounds terrible to say the best way to fire somebody, the right way to terminate somebody is do it with consideration for their dignity. That with most terminations and most employees, it shouldn't come as a real surprise. And that means that the employer should be in communication with the employee well before the date of the termination if there are issues with performance or conduct. And giving the employee a chance to improve and documenting everything that the employer is doing to, show that you communicated with the employee, you gave him or her every chance, and literally, hey, this is our last resort. Need to be thinking about the fact that somebody else might be looking at those records of yours, as to what you did leading up to the termination.
Welcome to Stop My Crisis. I'm your host, Vivian Gaspar, and if you've gotten some employees or you're looking to bring some on to your business, we are here with an amazing employment law attorney, Janette Levey Frisch, who has over 20 years of legal experience, more than 10 of which she has spent in employment and HR law, acting as the employer's legal wellness professional. Janette helps employers find proactive solutions to their workforce challenges to ensure that they're in the best possible position to avoid or minimize litigation, audits, employee relations problems, which often incur exorbitant costs. Janette, thank you so much. Your valuable insight can actually save a company or an employer possibly their whole business. So do you find that this has been a fantastic way to take your business as an attorney, as you have found that not just employers have questions, but concerns that need to be curbed from the initial start of hiring? For example, NDAs. Tell us about non-disclosure agreements.
Well, non-disclosure agreement is somewhat what it sounds like. It is an agreement that the employee signs, usually the employer offers it to the employee, and the provisions in there usually define what information must be kept confidential. And the agreement there is that the employee is going to keep that information confidential. There may also be language in there that indicates the consequences when the employee breaks confidentiality. So it's important for the employer to really determine what is the information that we're really looking to protect here. There's some information that it's not appropriately deemed confidential. If it's available through public channels, you can't require somebody to keep that confidential.
Janette, tell us, what about non-solicitation agreements?
Non-solicitation agreements are important when you are looking to make sure that your employees don't take your customers, your prospects, or for that matter, your other employees. So then you include language in an agreement that the employee will not, during the term of the agreement, which usually means their employment, or for a certain amount of time after their employment ends, solicit customers, prospects, or other employees.
What about intellectual property agreements? When does that become necessary for business?
Anytime an employee either creates intellectual property for a business or has access to it, is using it. And by intellectual property, I mean it could be artwork, it could be logos, anything that you would think would be a trademark. It could be anything patentable, like an invention. Anything that has any sort of originality is probably going to be intellectual property.
But are these really enforceable? Like the non-competes, how enforceable are they?
Well, the non-compete is another story. That has to do with restraining an employee from working for a direct competitor. They're also referred to as restrictive covenants. They are in all but roughly 3 states enforceable. California, North Dakota, I believe, and Montana are that, if I may sound a little irreverent, calling it the holy trinity of states that say it's not enforceable. They are enforceable in the rest of the United States if they're written properly and they're reasonable.
So when should an employer have an employee sign a non-compete? So which type of positions are they the most important for?
Roughly speaking, or generally speaking, I would say positions of trust. Positions where if an employee did go to work for a direct competitor and their knowledge of inside information is such that they could use it to the detriment of their former employer. So one example I can give, even a personal example, and it's a number of years ago, you wouldn't think you'd encounter it. One morning, my children were in nursery school. I'm dropping them off at nursery school, and the director came up to me and asked me to write an employment agreement for her teachers, and in particular, she wanted them to sign a non-compete. So teachers, no, that's not something generally. They're not going to have the formula for Coca-Cola that you're worried about. And okay, that's also a non-disclosure, but that you're going to worry they're going to take it to another school. People have a right to go somewhere else and make a living. I said, if you're just worried that they're going to go somewhere else, they're going to leave you, then be a good employer and treat them well so that they're less likely to leave you. But non-compete there is not appropriate.
So this is really helpful information to get started when working with the new employee. We're going to take a short break, and we're going to come back and talk about when you have someone you want to bring on, should you consider a 1099 agreement or bring them straight to W-2?
Anytime you can come into court and file for a change if there's a change of circumstances. We give an hour free consult. It's confidential. find out what has to be done.
We are here talking about bringing on employees, and so many people have thought it's a great idea to cut corners with some overhead expenses by making them W-2 alternative of 1099. So tell us, is that a good way for an employer to go?
Many times, no. The Fair Labor Standards Act presumes that workers are employees, not independent contractors. And so the presumption, even when you call someone an independent contractor, is that they're a misclassified employee. That doesn't mean you can't take on an independent contractor, but you want to be really sure that that is somebody properly classified, and that's why you speak with your friendly employment counsel to make sure that you're doing
Someone
it right.
just like you.
or yes, perhaps.
Just like you.
Perhaps, yes.
So what happens if you do misclassify someone? How does that come back to bite you?
Oh my goodness, it does come back to bite you.
Top two ways.
Top two ways. The withholding that you did not take, for payroll, Medicare, Social Security tax, those taxes that come out of a W-2 employee's withholding. So not only do you have to pay that, there's interest and penalties. And if the IRS or the U.S. Department of Labor think you were willful in that, there might be even more penalties and fines and interest. And it keeps building up because it's per violation, meaning for every worker that you did that with that you shouldn't have. So you can see how it just kind of snowballs. So that's one key area. For each person that you should have had workers' compensation coverage on, and you didn't. And by the way, the federal government, so I've been talking about the IRS and the U.S. Department of Labor, but their state counterparts also will come after you because they're not getting the money. It's about the money.
And so can you change, if you start someone off at a 1099 and you convert them over, let's say in 6 months, is that to be seen as suspicious?
Sometimes it will be seen as suspicious if you have good justification, and even better if it's documented what you did and why you did it. That certainly helps. And an employer would just need to be aware that there are certain indicators, certain behaviors that may be a red flag, and be ready to address that.
Can you give someone a rule of thumb when the employer is trying to determine whether the worker they're hiring can be classified as an independent contractor? Just one rule of thumb for that.
You look for the outer trappings of someone running their own business.
So 1099 should be running their own business as well.
Effectively, yes. So you looked at do they have any advertising? What do they do in terms of financial decisions with the company? Do they make any financial decisions, and the level of their financial investment versus the hiring party's financial investment? And also the work that that contractor is doing, if it's integral to the hiring party's business. So for example, you hire a house painter to paint your house, or you are a house painting company. You hire somebody to paint houses, that's integral to the business. In and of itself, there's no one test, it's a totality of circumstances, but that's one indicator that one might need to look further, that there might be something else going on. You hire somebody, the house painting company that hires the HVAC person to work on the HVAC system, that's probably an independent contractor.
But what about salespeople? If you had an all-commission salesperson, and my life and my time have been a W-2, but all-commission salesperson. Is that possible?
Yes, it's possible.
Without raising red flags?
It's possible, and it will, a lot of the factors that will be very important will be how the parties relate to each other. So another thread that runs through with all these factors is degree of control over the means, method, and manner of work. And I will say, by the way, there is no one test that's conclusive. So the IRS has a 20-factor test.
20 factors, it lets some leeway, not one thing.
Well, yes. Then you have the U.S. Department of Labor at 6 factors. And then you have each state that has their factors. New Jersey, it boils down to 3. They're, for the most part, similar. But you kind of have to look at all of those. And again, it's a totality of circumstances. So it's not, check, 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 okay, we have an independent contractor. Unfortunately, it's not that simple, which is why the questions and the confusion just abounds.
So the reason people do this, really quickly, what are the top 2 reasons that an employer will ask someone to be 1099 versus W-2? What are their overhead that they need to consider?
Well, the reasons why most employers do not want to take on employees and they would rather somebody be a 1099, I mean, again, I don't mean to sound very cynical, but money. They don't want to worry about workers' comp coverage. They don't want to worry about the withholding. They don't want to worry about the benefits. And they may be under the impression that there are certain other employment laws that don't apply to them. And sometimes that's true, but very often not.
And payroll itself costs something to generate payroll checks.
It certainly does. Really, with an employee, when you take on an employee, there are more expenses up front. It may avoid more expenses down the road, though, because if you misclassify somebody, well, you're also paying that friendly employment counsel that you didn't consult before to find out, make sure you did the right thing. Well, you're going to be paying them a lot more down the road when there's a mess that you're asking them to help you clean up.
Excellent. So we're going to take a little break, and after this, we're going to talk about if you do need to have someone work for you and they're W-2, part-time or full-time. What's the drawback and what's the positive? Welcome back. We're here talking to Janette Levey Frisch about employment law and when you are bringing on new employees, should they be part-time or full-time? Janette, do you need to offer benefits of any kind to a part-time employee?
Oftentimes, no. Depending on the benefits that you offer in general, you get to decide that with the exception, possibly, of health insurance. But other things like paid vacation, paid time off, there's no law in most situations that you have to offer paid vacation. Now we have state laws that do require a minimum amount of paid sick leave in some situations. But otherwise, subject to that, in many cases, no. With respect to a part-time employee, if somebody is part-time, meaning they work less than an average of, or they have less than an average of 30 hours a week of service.
I was just going to say, how many hours is part-time?
Yeah, so that would be, if it's less than that, then you don't have to worry about the Affordable Care Act, which is usually what the question is.
Do I have
do I have to offer health insurance? So I would say the general rule with a part-time employee is you don't have to offer health insurance. There may be business reasons to do it, though.
So the business reasons you're going to have part-time, we're looking at 30 hours, right? But is it more cost-effective than having two people? So you have one full-time person versus two people at, say, 25 hours each.
You know, sometimes it's really just a matter of crunching the numbers in that specific circumstance to realize what is or isn't effective. So I can't necessarily say across the board, yes, it's always going to be effective to hire one full-time person as opposed to two part-time people. So an awful lot of that is a business decision.
Well, that is something that a lot of people think on their minds. Can I just get part-time people? So thank you for answering that very concisely. It's really important to touch on that, in my opinion. But we really also need to look at what other behaviors can get an employer in trouble, right? So there's some risky behaviors. Stay tuned. Watch us next. In a few minutes, we're going to talk about what risky behaviors your managers, in addition to the employer themselves, should be aware of that could really get the employer in hot water.
What we provide is the experience that physician assistant, our pre-PA students need. The success rate of our program of having students accept at the PA school is 97%. All our students we have relationships with. Many of our students come back and help out. There's a lot of different challenges, but the students, we just do rapport with them and they're like our children. They really are.
We're here with Janette Levey Frisch, and she's talking about employment law and employers and their managers' risky behaviors. What exactly is a risky behavior by an employer or a manager?
Very often it's an offhand comment, just not even, that they don't even think about at the time that they make it. It could be they think they're just, ribbing somebody or teasing somebody, and, especially, unfortunately, with banter in the office that can cross the line to sexual harassment. Or it could even be a comment, a stray comment made about an employee who requested medical leave. Then you get into issues with the Family Medical Leave Act. Is that a retaliation for somebody exercising their rights? or somebody maybe who asks for medical leave because of a disability, and an employer is under pressure, or the manager is under pressure and doesn't want to deal with it, and so they say something, or they just tell the employee, look, I'm not dealing with this, or no, I can't let you take that time off. And without even realizing it, they may be in violation of several laws at once.
What about reprimanding? I mean, people, I could see where that can be a huge issue. You have to stop and be cognizant of laws taking place.
Yes.
But what about in the heat of a moment? You're upset that someone made a mistake. How about, what should they think about when they're about to reprimand someone?
So that sounds like you might be alluding to some possible bullying behavior, which happens.
But your employer never thought they could be bullies.
Most of them who are don't think that they're bullies. So, and it's a very fine line. So, and workplace bullying, at least technically, is not illegal. There is not, at least a federal law, there's no federal law that specifically says thou shalt not bully workers and defines what that is. Some states and localities do, though.
So what about when you are engaging with your employees, even your manager? So if you own the company and you have a manager, do you have to have that manager, or should you have them do any kind of a workplace employee training on how to engage with them?
I would say yes, absolutely. There should be some training. And the training would differ depending on whether the employee is a manager or whether they're staff. There are certain things, instances, for example, where an employer should train managers that there are certain things just should be handed off to HR, like the medical leave request. They should not be handling that. That should be either HR or an office manager, another point person that's not the direct supervisor. Other things, general issues with employee relations, yes, there should be training anyway. Harassment, discrimination, diversity, sensitivity training, it's often referred to as, but also it shouldn't be a one-off thing.
Well, how about just 2 simple tips that you think should be, remember in your brain, if you're not happy with something, don't do these 2 things. What would those 2 things be?
Don't berate your employees if you're a manager.
Especially in front of others, right?
Especially in front of others. There's a way to talk to people. How would you want to be spoken to if you were being criticized? Your performance, your conduct. That's, I think, that would be one rule of thumb that I would certainly give to managers. And I think that's actually a pretty good rule of thumb.
I think that's enough. Well, especially of
it should
your
be
tone
enough.
of voice. You should
Yes.
watch your tone of voice.
Yes,
Don't ever yell at anyone.
pretty much.
Well-
Yelling's not a good idea if you can help it.
So is there anything else that you could think of, really one last tip that you want to leave our employer viewing audience with?
Well, this may sound almost counter to it or opposite of what we were saying, but I do tell my clients, talk and listen to your employees. And what do I mean by that? Be the sort of person, not that they're going to tell you all their personal issues, but you want to at least come across as if you do care about what happens to your employees and what's going on in your workplace. You want it to be a workplace that is discrimination and harassment free, but you also want to have a heads up if there's a potential issue. And it's the employees who are going to be your best indicator of that. And they're the ones, they're often not surprised when they find out there's a problem, whereas the managers are.
Well, that's good to keep in mind. Yes, you need help, and Janette has been a valuable resource. Please consult a very experienced labor attorney, employment attorney, because this could literally make or break your business. It's the catch-22. You need people to work for you to grow, but if you don't handle it the correct way, it could literally mean the end of your business. Thank you very much for watching Stop My Crisis, and this is how we could stop your crisis.